Welcome to How to Divorce in Custody in California. If you're facing divorce, a child custody dispute, or have questions about California family law, you're in the right place. In this show, attorney Vince Davis and Ms. G break down the legal process into clear, practical steps you can understand. We'll explain your rights, answer common questions, and share strategies that can help you make informed decisions during one of the most important times in your life. And now, let's get started. Hello, everyone, and welcome back to the Family Law Show. I'm attorney Vincent W. Davis, and I'm glad you've joined us. If you've been with us before, welcome back. If this is your first episode, this program is designed to help you better understand California family law by answering real questions that people ask every day. Before we begin, I want to remind everyone that today's discussion is for educational purposes only. Every family's circumstances are different, and nothing we discuss today creates an attorney-client relationship or should be considered legal advice for your specific situation. Today, we're talking about one of the most important and often misunderstood subjects in family law, child custody. Specifically, what do California judges actually consider when they're making custody decisions?
Attorney Davis, after our last episode on child support, we received a lot of comments from viewers, but one subject kept coming up over and over again. People wanted to know about custody, not just who gets custody, but how judges actually make those decisions. I think there are a lot of misconceptions out there.
There certainly are. Many parents assume custody decisions are based on one dramatic moment or one parent's opinion. In reality, California courts look at a variety of factors, and understanding those factors can help parents better prepare for the legal process.
Attorney Davis, I hear the phrase best interest of the child all the time. It's in news stories, people say it online, lawyers mention it. What does that actually mean?
That's probably the most important concept in California child custody law. When courts make custody decisions, they're generally focused on what arrangement will best serve the child's health, safety, and welfare. People sometimes think the court is deciding which parent is the better person. That's usually not the question. The court is looking at the child's needs and evaluating the evidence presented.
So it isn't about deciding which parent wins.
Exactly. Custody cases shouldn't be viewed as a competition. The court's focus is the child, not awarding a prize to one parent or punishing the other.
This is probably one of the biggest questions parents ask. My child wants to live with me, or my teenager says they don't want to visit the other parent anymore. Can children simply choose where they live?
That's a common misconception. A child's wishes may be considered in some circumstances, particularly as children become older and more mature. However, that doesn't necessarily mean the child alone decides the outcome. The court considers many factors, and the child's preference is only one part of the overall analysis.
So a 14-year-old doesn't automatically make the final decision?
Correct. The court still evaluates the circumstances and determines what's appropriate under California law.
Let's say one parent handles almost everything: school, doctor appointments, homework, sports. The other parent isn't nearly as involved. Does that matter?
The history of each parent's involvement can certainly become relevant. Courts often want to understand the child's established routines and each parent's role in caring for the child. Again, every case is unique. There's rarely one single fact that determines the outcome. Instead, the court looks at the overall picture.
So people shouldn't expect one fact to automatically decide custody.
Exactly. Family law is rarely that simple. Judges evaluate many different facts together before making decisions.
Here's something I hear all the time. People assume the parent with more money automatically gets custody. Is there any truth to that?
Not necessarily. Financial stability can be one factor in a family's circumstances, but custody isn't awarded simply because one parent earns a higher income. The court's analysis is much broader than comparing salaries. The focus remains on the child's best interests under California law.
I think that surprises a lot of people.
It does. Many people confuse financial issues with custody issues. Child support and child custody are related in some ways, but they are different legal matters with different legal standards.
Attorney Davis, I hear parents say all the time, I have 50-50 custody. But then someone else says, I only have my child every other weekend. It gets confusing. Does 50-50 always mean the child spends exactly half the time with each parent?
Not necessarily. One thing that's important to understand is that people sometimes use the word custody to mean different things. There are legal custody issues which involve decision-making authority, and there are physical custody arrangements which involve where the child lives and spends time. Every parenting schedule is unique. Some families have equal parenting time, others do not. The court's goal is to determine an arrangement that serves the child's best interests based on the particular facts of that family.
So there isn't one standard schedule that every California family receives.
Exactly. No two families are exactly alike. The schedule that works well for one child may not be appropriate for another. Age, school, work schedules, distance between homes, and many other practical considerations may affect what parenting arrangement makes sense.
Here's something that's unfortunately common after a difficult breakup. One parent constantly criticizes the other in front of the child. Maybe they make negative comments. Maybe they blame the other parent for everything. Does the court care about that?
Courts generally want children to have healthy relationships with both parents whenever it's safe and appropriate. Parents should be careful about involving children in adult conflicts. Children shouldn't feel like they have to choose sides. They shouldn't become messengers between parents, and they certainly shouldn't be placed in the middle of ongoing arguments. When parents focus on their disagreements instead of the child's needs, everyone suffers.
I imagine children pick up on that more than adults realize.
They often do. Children are incredibly observant. Even when adults think they're protecting them, children can often sense conflict. One of the best gifts parents can give their children during separation is reducing unnecessary conflict whenever possible.
Attorney Davis, this question came up several times from viewers. What happens if one parent simply refuses to follow the custody order? Maybe they're always late, maybe they cancel visits at the last minute, maybe they refuse exchanges altogether. What should someone do?
The first thing I recommend is keeping accurate records. Document dates, times, communications. If exchanges don't occur as scheduled, make notes while the events are still fresh in your memory. Good documentation is much more helpful than relying on memory months later.
Should parents start arguing through text messages?
Generally speaking, no. It's understandable to become frustrated, but hostile communications often make matters worse. Whenever possible, keep communications focused on the child. Be respectful, be clear, and avoid sending messages you might later regret.
That sounds difficult when emotions are running high.
It certainly can be. Family law cases involve some of the most emotional situations people ever experience, but remaining calm and professional usually serves both the parent and the child much better in the long run.
Here's another question I see online all the time. One parent gets a better job, or maybe they want to move closer to family. Can they simply move to another city or another state with the child?
Relocation issues, sometimes called move-away cases, can be among the most complex custody matters in California. Whether a move is appropriate depends on many factors, including the existing custody arrangement and the particular circumstances of the family, because these cases can significantly affect a child's relationship with both parents. Courts generally examine them very carefully.
It's definitely not as simple as packing boxes and leaving.
No, Parents should understand the legal implications before making major relocation decisions involving their children.
Let's talk about teenagers. Suppose a 15-year-old says, I don't want to go to dad's house anymore, or I don't want to stay with mom this weekend. What happens then?
Those situations can be very challenging. As children grow older, their views may become more mature, and the court may consider their preferences in appropriate circumstances. But a child's statement alone doesn't automatically change a court order. The court still evaluates the entire situation. One important question is why the child feels that way. Is it a normal disagreement, a scheduling issue, or something more serious? Every situation deserves careful consideration.
So parents shouldn't assume my child said this, so the court will automatically agree.
Exactly. Family courts generally look beyond one statement and consider the broader context.
Attorney Davis, I know many parents hope to avoid a courtroom if possible. Can mediation actually help?
For many families, mediation can be a very valuable process. Instead of asking a judge to make every decision, parents have an opportunity to discuss issues and work toward agreements. Not every case settles through mediation. Some require judicial decisions. But when parents are able to communicate effectively and reach reasonable agreements, mediation can often reduce conflict and give families more flexibility.
I like that idea because at the end of the day, the parents know their own family better than anyone else.
That's often true, and when parents are able to cooperate, children frequently benefit from that cooperation.
Attorney Davis, we've talked about what judges consider parenting schedules, move away cases, violations of custody orders, mediation. But before we finish, I want to ask you about the biggest mistakes parents make before they ever walk into court. And I'd also like to hear your advice for someone who's just beginning a custody case for the very first time.
Those are excellent questions. Let's spend the rest of our time talking about how parents can better prepare themselves and avoid some of the mistakes I see far too often.
Attorney Davis, throughout today's discussion, you've mentioned preparation several times. If someone has a custody hearing coming up, what are the biggest mistakes you see parents make before they ever step into the courtroom?
That's an excellent question because many custody cases are influenced long before anyone walks into court. One of the biggest mistakes is allowing emotions to control every decision. I understand why. When we're talking about your children, it's emotional, but judges are looking for facts, evidence, and what's in the child's best interests, not who is the angriest or who can tell the longest story.
I imagine emotions are probably at their highest in custody cases.
They often are. Parents are worried about spending time with their children. They're worried about the future. They're worried about whether they'll be heard. Those feelings are completely understandable. But it's important to separate emotions from legal strategy.
What's another mistake?
Poor communication. Sometimes parents send dozens of angry text messages. They post about the other parent on social media. They involve grandparents, friends, or even the children in adult disagreements. Those actions rarely help. Whenever possible, keep communications respectful, child-focused, and professional.
Even if the other parent isn't being respectful?
Yes, you can't control someone else's behavior. You can only control your own. One thing I've learned over many years of practicing law is that professionalism often speaks louder than anger.
You've mentioned documentation a few times today. Why is documentation so important?
Because memories fade. People honestly remember events differently. A calendar, emails, text messages, school records, medical appointments, parenting schedules, those types of documents can help establish a timeline of what actually occurred. Documentation isn't about collecting evidence against the other parent. It's about accurately preserving information.
So instead of saying, I think this happened 3 months ago, you actually have something to refer back to.
Exactly. Clear records are generally much more persuasive than relying solely on memory.
Some parents watching today may be thinking, This all sounds great, but my ex and I can't agree on anything. What advice would you give them?
First, understand that you're not alone. Many parents struggle with communication after separation. The goal isn't necessarily becoming best friends. The goal is becoming effective co-parents whenever that's safe and appropriate. One thing I encourage parents to remember is this: your relationship with each other may have ended. Your relationship as parents continues. Your child benefits when both parents can focus on the child's needs instead of continuing old arguments.
That's probably easier said than done.
Sometimes it is, but every positive conversation, every successful exchange, every respectful interaction creates a better environment for the child. Small improvements can make a significant difference over time.
Attorney Davis, let's say someone's hearing is tomorrow morning. What's your advice?
Arrive early, dress appropriately, bring organized documents, listen carefully, answer questions honestly. If you're represented by an attorney, discuss your concerns before entering the courtroom. Most importantly, stay focused on the issues the judge needs to decide. Remember, the courtroom isn't the place to settle every disagreement you've had over the past 5 years. It's about addressing the legal issues before the court.
I think that's something many people need to hear. Sometimes people feel they have one opportunity to tell the judge every single thing that's ever happened.
That's understandable, but judges generally appreciate organized, relevant presentations. Staying focused helps everyone.
Attorney Davis, if our viewers remember only one thing from today's episode, what would you want that to be?
I'd want parents to remember that custody cases are ultimately about children. It's easy to become focused on disagreements between adults, but courts generally return to one central question: what arrangement best serves the child's interests? When parents keep that question in mind, they're often in a better position to make thoughtful decisions.
So instead of asking, how do I beat my ex? Maybe the better question is, how do I help my child succeed?
I think that's exactly right. When parents shift their focus toward their child's well being, conversations often become more productive. Again, I understand that some cases involve serious allegations or safety concerns, and those situations require careful legal attention. But in general, keeping the child's needs at the center of the discussion is beneficial.
Attorney Davis, before we wrap up, I wanted to mention something. We've already received questions for future episodes. People are asking about grandparents' rights, move-away cases, emergency custody, modifying custody orders, domestic violence restraining orders, and even what happens if a parent wants to relocate to another state.
Those are all excellent topics, and we'll definitely cover them in future episodes. One thing I hope viewers understand is that family law isn't just about divorce. It affects parents who were never married. It affects grandparents in certain circumstances. It affects guardians. It affects blended families. There's a lot to discuss, and we'll continue answering those questions one episode at a time.
Attorney Davis, thank you again for taking the time to answer these questions. I think what stood out to me most today is that so many of the assumptions people have about custody simply aren't accurate. It isn't about who earns the most money. It isn't about who tells the saddest story. And it certainly isn't about trying to win against the other parent.
That's right. Family law is often misunderstood. My hope is that these conversations help people better understand the legal process so they can make informed decisions for themselves and their families. As always, today's discussion is intended for educational purposes only. Every family is different, and the outcome of any legal matter depends on its unique facts and the applicable law. If you're facing a child custody issue, have questions about parenting time, or are involved in another family law matter, it's important to seek legal advice that's specific to your circumstances. If you'd like to learn more about our office or schedule a consultation, we'd be happy to speak with you. If you enjoyed today's episode, please subscribe to the channel, leave a comment with topics you'd like us to cover in future episodes, and share this discussion with someone who might find it helpful. I'm attorney Vincent W. Davis. Leave your questions in the comments. We may answer them in a future episode. Thank you for watching, and we'll see you next time.